owed our client still a balance of $6 million on the $8 million note that was given to him. This was not, as appellant would want you to believe, something where it can be easily divided or distinguished. Our clients loaned $8 million to Vince Hesser and his entity Bullhead 1117. Through a series of events and over the years that passed, Bullhead 117 filed bankruptcy, the entity MPOC filed bankruptcy. So this lawsuit in Arizona has had many different plaintiffs and defendants and entities come about. While the appellant argues that Bullhead 315 was not a named party in the Nevada suit, I believe when that suit was instituted by other counsel in Nevada, Bullhead 315 did not exist as that entity. Bullhead 315, if you look at the record in this case, became a named plaintiff after a reorganization of the original plaintiffs. And if you look back at the case history in the Arizona case that we're here on, the same law firm at one point represented OneCap as a plaintiff before their bankruptcy. So there have been a lot of different named parties, and this case has gone through many different things, but I don't believe the court was confused. In exchange for our client's note to Mr. Hesser and his entity Bullhead 117, Mr. Hesser gave not only his personal guarantee, but he also assigned the notes to the Allers. And those notes were the $13.5 million note and a $27.5 million note. Mr. Hesser successfully foreclosed on the $27.5 million note. Mr. Hesser, in this matter, is related to his attempt to foreclose on the $13.5 million note. Our client's defense, once he learned of the trustee sale and foreclosure action on that note, his defense and the reason that First American rescinded the trustee sale is our client showed that he was 100% owner of that note, and that was from the assignment that came from Vince Hesser related back to the $8 million note.
And you're saying that's not confusing?
I kind of thought afterwards.
A $23 million note, a
yes.
$13 million, $8 million note. The issue here is
yes.
the $8 million note, right? And whether OneCap can foreclose on as having a reassignment. Is that what the issue is?
The issue is if out of the $8 million note, some repayment of that caused a 25% or so assignment to go from our client to the plaintiff so that they would have an interest to foreclose on the note.
Isn't there some evidence that in fact happened?
There is no signed agreement.
Does there have to be a signed agreement for the other side to win? Can there be evidence that shows
there can be other evidence? I don't believe that there is other evidence. The best evidence and what was tried to be presented by the appellant at the trial court level was the relying on an agreement between Mr. Hesser and the Aller Family Trust. And again, while that was drafted, it was not executed by both sides. So
is there email correspondence between counsel that suggests that an agreement's been reached?
It was drafted for both sides' review, but it was not signed by both sides. So
was there a representation? I guess let me put it this way. Mm-hmm. Was there a representation by the Allers counsel that this is the agreement, our client has agreed to this, if you'll sign it and send it back to us?
I don't believe it was that express, no.
But there was something along those lines?
There was an agreement drafted, and I believe it was based on what Mr. Hesser wanted at the time. But when the parties went through, finished their agreement, it was not signed by our client, and it was never brought up as an issue until this case. It's never been brought up as a defense by Mr. Hesser that he didn't owe the funds. He's never claimed, I owe less of it or anything along those lines because of an assignment. So.
OneCap wanted to foreclose.
Yes.
On the security.
Yes.
Saying it had an interest in the house because of the reassignment.
Yes.
You're right so far?
Well, all the lots, yes.
Okay.
Yes.
Okay. Secured property.
Mm-hmm.
And in essence, the Allers contended, you don't have any interest in the lots.
Correct.
Because even though I may have been paid $2 million, I've never signed the reassignment.
Right, and
Fair?
I wanted to be clear that our clients were never repaid $2 million in cash. There was a workout agreement that would have resulted in a $2 million exchange of other properties, which never went through. But nevertheless, the Nevada court gave Mr. Hesser a $2 million credit on that underlying note. Not to add more confusion to it,
Okay.
but
Your clients got something of value for, did they get $2 million of value?
no. At the end of the day, their what was supposed to be their workout agreement did not go through.
So the
So-
workout agreement, so there never was a amount paid or in any form to the Allers for $2 million.
Correct.
For the value of $2 million, or anywhere near that amount.
Correct. Yes.
And
Correct.
that's why, so the argument, your response to the argument of counsel, as I understood arguments counsel, your opponent's counsel was, well, gee, we agreed, Mr. Allers counsel sent us the reassignment. So here's the deal. We signed it, we paid them $2 million, or we gave them something in the form of $2 million worth, and then he refused to sign it. And the court said, fine, there's no reassignment, which is sort of like a promissory estoppel or reliance argument. So is your argument, one, they never received any, there's no evidence that they received anything for that?
Correct.
Regardless of whether he relied on it, there was never any exchange of value?
That's not the argument we're relying on here, because the Nevada court has already found that he's allowed $2 million credit on the note. But our main argument here is that our clients did not enter into the reassignment agreement with Mr. Hesser, so no percentage of their interest could have been assigned back or
It
reassigned.
sounds like they're making a sort of a promissory estoppel that regardless of whether you say there was, Nevada court found that he was entitled to
A credit,
that
yes.
he got entitled to a $2 million credit.
Yes.
Did he get it? I mean, did he receive? I mean, he must have received some money or something of value to have a $2 million credit.
The Nevada court found that he should get a $2 million credit, yes.
Mr.
Hesser, on
Hesser should get $2
on the
million.
underlying $8 million
$8 million
note.
should get
Yes,
$2
that now
million.
it's down to 6.
And now they're saying, well, they got that. Why do you need a signed reassignment if you've got that court's finding? Now I am really confused.
Well, you're just saying, you agree that you're bound by the Nevada judgment. The Nevada judgment has basically recognized that your client received $2 million in value, to which Hesser or somebody was entitled to credit against the note.
They give him credit against the note, yes, for $2 million. There was no finding that the reassignment clause was in effect, though. I think you can distinguish between Mr. Hesser being off the hook for having to repay less of a note to our clients. I don't think it necessarily has to follow that our clients reassigned their interest. Because if
Right,
you
so
look,
I mean, I guess that's the question that's presented to the Mojave court, correct?
yes, well, not really the question, the presumption that was taken to the Mojave court for the basis of the lawsuit was that, it should have gone forward and it needs to be reinstated because Mr. Allers did not have the power to revoke it by claiming he had 100% interest because he only had a fractional interest. That was the basis for the complaint to begin with,
Right,
to
but
reinstate.
the theory is that since Nevada court's already recognized that Hesser paid Allers $2 million, then through some theory, they must claim that they are entitled to reassignment of that 25%, either because of an express contract
Well,
or through some equity or
this case
some other
started
doctrine.
before that case and well before the Nevada court ever made that ruling. So that wasn't the argument in Arizona. The argument in Arizona all along was there was a valid reassignment, and their alleged proof to that was here's the
Emails.
unsigned, well, it was the unsigned agreement. Hey, this was drafted and it should have been the final document. So,
Regardless of which case started first,
sure.
why wouldn't we be reversing if there's a finding by the Nevada court that Mr. Hesser
It's Mr. Hesser.
Hesser
Yeah.
is entitled to a $2 million credit in the $8 million loan. And there are these emails that go back and forth that would seem to indicate at least a fact question about whether the the Allers Council had agreed, yes, this is the agreement, we've reached this agreement. Hesser signs it.
Sure.
And sends it back, and then Mr. Aller says, no, I'm not going to do it. I mean, is there a promissory estoppel type of argument here, or an equitable estoppel, or a reliance argument that was made below that would create a fact question about one cap's ability to foreclose?
When we asked the court in Arizona to rely on the Nevada ruling, part of the Nevada's finding of facts was that Allers blocked the foreclosure in Arizona, and it was by his valid assignment of that note, and then his lack of consent to the foreclosure in Arizona. So I think the court not only relied on our arguments that Mr. Allers still owned 100% of the note, but that the Nevada court had found that he didn't consent to the foreclosure in Arizona as well. So the court in Arizona never even made it to the next step to decide if there was notice of the trustee sale, if that was even something that had to be argued, because the court here found that Nevada had found, okay, 100% to our client, so no foreclosure could have ever gone forward.
So you're saying you're justifying the Mojave judgment based on res judicata from Nevada?
Yes. Or alternatively, that they got the right conclusion with.
And the res judicata argument, now, this is such a simple case, but so I'm sort of like struggling.
Right, because it can only be the right conclusion if there were no disputed facts. So if res judicata was not proper, and it's argued that it was not proper because Bullhead 315 was not a party, correct?
Correct, but Bullhead 315 didn't exist at that time.
That's the argument.
Yes.
But if you want us to say that the judge was right because he was right, then you have to show us that there were no disputed facts that would have called for a trial of those disputed material facts, correct?
Right. Correct. And just so that this court's clear, Bullhead 117, and I don't know if it'll make much sense here, the 1,117 was the acreage of the development that was at issue. It was then broken into different parcels, 315, 640, different named companies, if that. But when you do the math, it's still 2 acres short, if that makes any sense.
Your reliance on the Nevada judgment on res judicata.
Yes.
It's not because of the $2 million, finding of the credit $2 million.
No.
Because that's actually adverse to you.
Yes.
But your argument is on res judicata is that the Nevada court said, well, gee, Mr. Aller never consented to the foreclosure.
Right, and finding that the note, the $8 million note, was owned 100% by him, and that Mr. Hesser was in default and had no defense to being in default of that. So whether he got a credit of $2 million or not, the court in Nevada did not make a specific finding about the reassignment clause, but they did find that the Arizona court lacked consent of our client, and that the foreclosure should have been stopped.
Now, I know we want to get to Mr. Mull, but
yes,
just before
sorry.
you finish, did the Nevada court say that the Allers owned 100% of a note at $6 million?
Yes, the judgment to our client is for the $6 million plus interest. It actually made it $14 million something. Okay. So yeah, there was no dispute about the percentage of the note.
I think we're going to need to get to Mr. Mull.
Okay. I appreciate your time. Thank you.
May it please the court, Scott Malm of the law firm Gust Rosenfeld. I substituted in for the late Dick Siegel, who handled the briefing on this. Substantively, we follow much of what the Allers have said. Maybe if I could simplify this just on that concept. Let's say there's a mortgage that Ms. Connor has on her home. If I come along and I pay that, let's say it's an $8 million home, nice home, and I pay $2 million, that may give her a credit for what she may owe, but it doesn't mean that a real property interest at all was transferred transferred or changed. And I think that's why you can draw a distinction here between the Nevada court saying we're going to give a $2 million credit for the payment, but not necessarily make any change in the real estate interest that is being handled there.
We understand the difference between the indebtedness and the nature of, and the security or the property ownership. Is there not an argument in this case that Bullhead 315 is entitled to a reassignment through some equitable theory?
No.
Argument is just based on an actual agreement to reassign.
You would have to have some kind of written agreement of some sort, not equitable, for the change in a real estate interest.
But now I'm
And here's
talking
why,
about
because
but the argument that you're facing.
yes,
The
because
argument is based on that the court erred in refusing to allow Bullhead 315 to put on proof that they had an agreement by which they were entitled to 25% reassignment.
Correct, because here's what the issue is: the only way they could get to through equity.
Well, if there isn't an equitable argument, I don't want to make one up. I'm just trying to see if there is one in the case.
The only one that could exist would be a doctrine that we've been hearing about through the mechanics liens and other issues, would be an equitable subrogation type argument. If they paid a certain dollar amount for the release of that interest, they could subrogate and assert that interest. But as the White's Heth Supreme Court case just resolved, which was one of our cases that I handled, you can't have partial subrogation. So by paying only $2 million down, they can't step into the shoes of and say, well, that was 25%, we get a 25% interest. So there's no equitable argument to get into the real estate
Hence,
interest.
their argument is that there's an actual agreement to reassign.
That's why they have to get to an equitable argument. But if they do that, it would only be a claim not on the real estate interest side, but only in a contractual type relationship. You breached our contract. We agreed to give you $2 million if you would give us the real estate reassignment type
But they
thing.
have to get specific
But there is not,
performance.
so they would just,
They would have to get specific performance to force the actual reassignment, then they can do something with that?
then maybe that might change everything if they were down the road.
But let me get to this sort of reasonable reliance or contractual, lieu of contractual, like express contract, promissory estoppel type of argument. As I understood, I mean, one aspect of that is, okay, I'll give you $2 million, or some property worth $2 million. You give me a reassignment. They say, okay. I give them the $2 million, and they say, we're not giving you the reassignment. That's, I think, the premise for the promissory, what I've been hearing today. Is there evidence of that in the record?
I'm not aware of any because we've been relying on Ehlers for the substantive part of it. My understanding is that all there is just the unsigned document. There isn't the emails talking about that kind of reliance.
Or emails. I mean, if the point is, you know, if someone says, I mean, the presumption is, I'm going to give you $2 million if you sign a reassignment. You say, okay. I send you the $2 million and then you don't sign it. I may have a promissory estoppel to get specific performance on it, or go ahead and foreclose and argue that I've got an interest I can foreclose on. And I've heard everything about the emails, or I've heard things about the emails. I've heard things about $2 million. I've heard things, but I haven't heard, and I've seen there's no signed agreement. I haven't heard anything about, well, I paid $2 million for that assignment.
Well, and until they would do that, they wouldn't have a right to foreclose. And if they don't have a right to foreclose, that's where we really come in as First American on our argument, which is until you prove you had a right to foreclose, you can't sue us for not going through the
What
foreclosure.
about the argument that this had nothing to do, that your foreclosure, your breach of duty and the claim against you had nothing to do with the $8 million? Is that what I understood the argument to be?
That's what I understood the argument, but here's the problem: when you don't object in the trial court, we can't argue, we don't know all of those details, so that's one of the first times I've really heard that type of argument. That's not what I'm understanding from getting the details from the Ehlers position, that's not the case. But that's why we're behind the 8 ball in a procedural situation. Object in the trial court so we can have that fight, not standing before you here today. Any questions for the First American position? It is the procedural part. If you don't object in the trial court, then there's no basis.
One
That's
question,
our position.
why doesn't their objection to the summary judgment motion preserve the issue as opposed to objecting to the order, the judgment?
You mean objecting to the summary judgment, the first round of summary
First round
judgment?
of summary judgment.
Clearly, there's two different legal situations. The first round of summary judgment issues were about, is there disputed issues, the fact of whether the title company would have a duty to conduct a foreclosure based on the relationship and the contracts and the agreements of the parties. There may have been, as the court found, a disputed issue of fact about that, but nothing argued in that round was whether you have the right to foreclose or not. That issue didn't come around until later after the Nevada court decision. So once that legal decision is made, you don't have the right to foreclose, then the logical conclusion is you can't sue somebody for not foreclosing then. So they're two different legal issues. That's why objecting around here doesn't change what this legal decision was here. Anything else, Your Honors?
Thank you, counsel.
Thank you.
Mr. Conner, you're the last man standing.
Thank you, Your Honor. First of all, Ehlers has contended today that there is no evidence of an agreement to reassign. And you are exactly correct. We did assert promissory estoppel, and the evidence is an email from their counsel that is in your record, and it expressly says, here is the final agreement, sign it. And then $2 million was, in fact, paid.
And where's the fact of the $2 million being paid or transfer of value of $2 million based on the idea that the Allers were going to sign that reassignment? Where is that in the record? Tell me where
That
is
is, standing here today, I can't tell you where it is, but there is, in fact, evidence of the $2 million payment.
Tell me generally where it is. Is it in the response to the motion for summary judgment?
Okay.
Just tell me if it's there.
Yeah, I recall that there is a document that reflects a $2 million credit. It's an enormous record. The places I would look would be in the, I'm sorry, Your Honor.
Go ahead.
I'd even be willing to go back and find it. And
You're all right if you were to just
But
provide
I-
a supplemental citation without argument.
No
just
argument.
alerting us to where we
I
would
would-
find it.
Where it is, that, again, my question is, where is it the $2 million was transferred in reliance on the Allers signing the reassignment?
And in exchange for.
Right.
okay,
And all you
I
have to do is
wanna
show us
be-
where that is in the record.
okay, I want to be really clear with you. You will not have a document that says, here's the $2 million in reliance on this.
Right, but
What
what's
we-
in the record that establishes that as you asserted?
That the $2 million.
Your assertion is the
Yes.
$2 million was paid in exchange for an agreement that there would be a $2 million reassignment of the
Okay.
property value.
And my evidence of that is the reassignment condition. There was two provisions. Above, it was for Mr. Hesser to sign. Below was for Mr. Ehlers to sign. Mr. Hesser, in fact, signed. Mr. Ehlers claims he did not. We presented to the trial court the complaint in Nevada, wherein these facts were stated, and in that document is the statement that Ehlers received the $2 million. And we also have an affidavit from Mr. Ehlers that he received the $2 million.
But do you have any, okay, so tell us where the affidavit is.
And I
Where you
will do
filed
that.
it, and tell us where in the record there's any evidence that the $2 million was paid in the, either on reliance on or for the exchange of the reassignment.
Okay, and
Okay? That's all you gotta do is show us that.
okay, and
Something
I'm
else?
telling you, I'm going to give you the actual emails between the parties.
And I think we know where the emails are.
Okay.
But if your client had a right to the reassignment under whatever theory, didn't you have to go get the reassignment, go to court, order specific performance, have the property actually transferred to your client, then he can go foreclose?
Well, the foreclosure was seeking a deed that was 7525. The foreclosure was noticed. The foreclosure was actually conducted. I'd like to slip over to Mr. Malm's argument. He's saying, well, you got to deal with this first. Well, First American actually conducted a sale. The gavel went down. Bang. The sale happened.
They apparently must have concluded that they were in error to do that.
Well, that's not the way the statute works. It is conclusive, and that was the fight in the trial court, and those are the arguments that were fully briefed and fully presented. That was the contention, and the trial court said, we're going to go to a trial on this, because I'm not sure why First American did what it did. I need to get to the bottom of the facts. And we have asserted, yes, we asked for specific performance. We've asked for a number of different claims to try to get to a deed for this property, 75% for the plaintiffs, 25% for Ehlers, but the trustee sale had already occurred.
Yeah, but that isn't what happens. What's conclusive at a trustee sale is that the buyer at the trustee sale gets whatever the person who was foreclosing had to give, right?
No, I don't believe that to be the law. What
I mean, if it's determined that the person bringing about the foreclosure had no interest in the property, that's still good?
I think, Your Honor, that's what a lot of people are now arguing, that these DocuSign deals where, oh, you didn't really have a proper assignment of my deed of trust and you couldn't properly foreclose, and all the cases are saying, absolutely not. The trustee's deed has gone down, the gavel has hit, the sale has occurred. We don't undo that, and that was what was presented in the summary judgment arguments involving First American. So that is a fact question, and the sale has happened, admittedly, and there is absolute proof that Ehlers had notice before the sale went through. We have a certified receipt. Go ahead, Your Honor.
Just briefly get back to the specific performance argument.
Yes, Your
What
Honor.
you're arguing is you didn't have to get an order of specific performance to have the Ehlers sign the reassignment. Because what you're arguing is, if I understand it, is if the trial court bought your argument about, I paid the $2 million in exchange for the reassignment, and then he refused to sign it, all the court would have to do is issue allow us to foreclose to get a trustee's deed that would say 75-25.
Allow us to record everything precisely. Allow us to record the trustee's deed 75-25. Yes,
That
yes, Your
would
Honor.
have been in lieu of a specific performance.
Precisely, Your Honor. Precisely, Your Honor.
I got it.
Then there was a second argument that the Nevada ruling, and I have the Arizona case ruling. The words of the trial court are, plaintiff is not a party to that, referring to the Nevada case, period. That's been found. So I don't understand.
The opposing counsel seems to agree with that, since her position is you didn't exist.
Well, but she also made the argument that she said that the Mojave County judge did not make that finding, and I'm telling you, it's here. And then the findings that the Mojave County judge has made are relying on a Nevada case, or a Nevada ruling, and Nevada had no jurisdiction to make any rulings about the deed of
He
trust.
also says there was no signed reassignment.
Absolutely. He says, but in his affidavit, he says, I didn't sign it.
I understand that. The court makes a finding there was no reassignment.
In Nevada or
No,
here, the court said Ehlers never signed the reassignment provision of the original promissory note. Yes, Your Honor. Okay. You also asked about the implications of the res judicata. You can't have res judicata without the requirements, and I think we've demonstrated that they don't exist. I think I'm out of time, and so I thank you very much for your time and your attention to this very complicated case.
You all, counsel, for your arguments. I'll take the matter under advisement. We'll issue our decision in due course. Court's adjourned.
see you. Yeah, take care. I'm sorry I wasn't there for the Harrison. I guess you guys got the PFP going, so, yeah, just, I mean, I think we. Yeah, you can't get that kind of thing settled. Yeah, I think you're fine.
Going in the wrong way.
Yeah, I went to a little bit of that. Yes, it was nice to meet you in person since we only argued over the phone. Yeah, and Mrs. Brent Welker with my office. And now you have to drive back to Kingman.
Bullhead.
Bullhead.
Oh, another
geez.
hour passed.
Oh, geez.
But you know what? That's all right. It was good weather, so I can't complain. You guys got rid of the rain you had, so
Oh,
okay.
if I could just get my voice back.
Oh, you guys have had it, haven't you?
Oh, terrible. And it's better. My voice, believe it or not,
It's
this is
better.
good.
Yeah. Even driving in, it looked like there were places with standing water.
Oh, yes.
Assuming people
Oh,
would
yeah.
have it.
That's why I said I think it's official. I am a desert rat.
Right.
I am so allergic to rain.